we'll be sitting down for this. I'm Rachel Rosenblum, and I teach immigration law and refugee and asylum law here at Northeastern, and I'll be moderating this panel today. And we have an amazing set of people here, this roundtable, I should say. And I just want to say a couple brief words. We're here because twice a year the law school brings a public interest practitioner here as a Daynard visiting public interest fellow, and we all here at the law school get to benefit from interacting with them and learning from them, and then through events like this we open it up to the wider public. So I hope I put the word out. I hope there's a few people here from outside the law school. I think there are. And I just want to thank Janice Galligan and the Dean's Office and Professor Lucy Williams and all the students and staff who work on selecting the fellow, coordinating the visit, doing all the hard work to make this happen. And then I get to come up here and do the fun stuff when it's all put together. So thank you very much. Our Daynard Fellow this term is attorney Carlos Spector, who is from El Paso, Texas, and he is a dual citizen of Mexico and the United States, and he has been he's been practicing immigration law in El Paso for over 20 years, particularly specializing in representing asylum seekers from Mexico. Much of it done pro bono, really groundbreaking work representing people fleeing violence and corruption there, and journalists, whistleblowers of all sorts, and he'll be telling you more about his work. He did a wonderful talk here on Monday that I think many of you were at about his work, and so today he'll be giving us a very brief synopsis of the issues that are raised by his work, and then we have invited several people who are based here in Boston to reflect from their own perspective on the issues raised by his work. So we have here. I'll introduce everyone now, and then I'll say a few introductory remarks, and then I'll hand things over to Carlos to kind of to start us out, and then we'll go to each of our other participants. So we have here Carlene Desiree, who is the executive director of the Association for Haitian Women in Boston. She's been an activist in the greater Boston community since 1984 and has founded or co-founded several organizations and coalitions. She previously worked as a teacher and a social worker and a manager. She holds a BA in International Relations and a master's in Community Economic Development, and serves on the Massachusetts Governor's Council to address domestic and sexual violence, on the advisory board of the Massachusetts Department of Children and Families, and the Boston Haiti Health Support Team. And we have, I'll go in order. I've already introduced Carlos. We have John Wilshire Carrera, who is a 1985 graduate of this law school, and the co-managing attorney of the immigration unit at Greater Boston Legal Services, as well as a clinical instructor in the Harvard Immigration Clinic, which is based at GBLS. And he is a nationally known researcher and practitioner in the field of immigration. He's been the recipient of a number of awards for his legal services work. And then we have Sarah Ignatius down here at the end. She is the executive director of the PAIR Project, which is the Political Asylum and Immigration Representation Project, which works with hundreds of pro bono attorneys to represent asylum seekers here in Boston. She has been there since 1993. She is the author of the book Immigration Law and the Family, and also as well as the author of numerous articles and reports on asylum. In particular, she was in 1993 the principal researcher and author of a nationwide study on the asylum officer program. It was funded by the Ford Foundation. So thank you all for coming. And our topic for today is the politics of asylum adjudications. People can apply for asylum by submitting an application to U.S. Citizenship and Immigration Services. or if they're in removal proceedings already, they can apply to the immigration judge as part of their removal proceedings. And both forms of adjudication have been the subject of quite a bit of criticism and commentary over the years, and we'll be adding to that here. There's a number of different ways one could look at these issues. Some people have focused on the lack of procedural safeguards. These are very high stakes kinds of cases, often life or death, with very few procedural safeguards. One commentator has described an asylum hearing as being like holding death penalty cases in traffic court because of that combination. And actually, that was the person who said that was an immigration judge. So she knows what she's talking about. So that's one angle one can take on adjudications. Another angle is to look at the disparities in the variations in the grant rates of different adjudicators. You have immigration judges who grant 96% of the cases in front of them, and you have ones who grant less than 2% of the cases that come before them. The numbers are all over the place. And by the way, one of those less than 2% is in El Paso, so I'm sure Carlos has to deal with him. So that's another way one could look at this. One could look at the variations in success rates between people who are represented by counsel and people who aren't. And then one could also look at some of the trends in terms of the countries people are coming from. And that's really what we're here to talk about today, that people from certain countries have found it much easier to get asylum than people from other countries. And we can look at groups and see just extraordinarily low grant rates, extraordinarily high hurdles. And the Mexican cases would fall into that group. And that's really what Carlos has been talking about in his time here and what his work has been focused on. But they're not the first group to have experienced those kinds of barriers. And so the folks we have here today have experienced, can bring a kind of a comparative perspective, looking at other groups that have gone through this experience and what the responses have been. And we've deliberately not just invited lawyers, but also invited community activists to kind of broaden it out and think about not just what are the legal responses, but what are some of the advocacy and organizing responses that one might have to a situation like that. So without further ado, Carlos, why don't you get us started by talking about the Mexican cases?
Thank you. I've been involved in the immigrant rights movement since the early 1980s, and we're detecting certain patterns in the treatment of the Haitian, the Central American, and now the Mexican community. And much of the experiences that we're going through are experiences that other communities have gone through. And the first thing we have to understand is, I think, that immigration law and policy is essentially is not essentially, but very importantly also a foreign policy consideration. And we see that being played out now in Mexico. And what we have now is a failed war on drugs, on steroids in Mexico, that if the war on drugs here could have been implemented the way certain elements in this country would want to have it, they would have released the soldiers into the field. But they couldn't do it there, so they did it in Mexico. And so we have a non-law enforcement entity, the military, that has historically remained in the barracks for national disasters and to drum up a couple of leftists here and there. But what we've seen as of 2006, when President Calderon was elected, we had the release of the Mexican army from the barracks for the first time in its history. And that's had a humongous impact on the violation of human rights in Mexico, and especially in the state of Chihuahua, which is across from Texas, where I live in El Paso. And what we've seen in our work in representing individuals is the genocide of the murder since the Mexican military came of 21 human rights activists in the state of Chihuahua alone. From 2003 to 2006, there was 600 complaints against Mexican soldiers. 2007, 2010, over 5,000. This is funded with many monies. So to grant, and I'm summing up because I only have 5 minutes, but to grant a Mexican asylum claim is essentially to acknowledge that the Merida monies, which is responsible for the training and equipping of the Mexican army, is responsible for the advance of increased number of Mexican asylum claims and human rights abuses in Mexico. On and on I can go with the horror stories, but just to say that at this point, 97%, 98% of all Mexican asylum claims nationally are being detained. The closer to the border the judge is, the higher the denial rate of the Mexican claims. And this is premised, I think, on them getting the memo. I say this publicly in Mexico, and I'm debating the judges all the time in private. And basically they say, well, we're just judges who apply the rules to the law. 90% of them are prosecutors. That's the political context in which we function, either ex-U.S. attorneys or ex-trial attorneys who used to work with the trial attorneys who are now prosecuting before them. It's an incestuous relationship that they worked for these individuals for 10 years or more. Now, these judges also rely very heavily on the State Department report. And the State Department report is but one of many documents they can rely on, but most of the judges that we've seen in the Mexican cases, and I'm sure in all the other cases, put undue emphasis upon the State Department reports. The State Department report, or the human rights report by the State Department, reflects our current national policy vis-a-vis Mexico or any country. And it's not just a summation of the reality of that country, but it's generally a very gingerly approach to the situation in Mexico. You know, Mexico, at this point, 40,000 people have been killed. It's up to maybe 50,000 by other reports in the last 6 years. In the city across from where I grew up, Juarez, 10,000. The deadliest city in the world, El Paso is the safest. So we have people fleeing Juarez in massive numbers. We have no foundation monies, as everybody else as well. We have very few nonprofit organizations that are attacking the problem. And I think part of the reason I was invited was to give you an alternative perspective in terms of how you can serve the public interest without working for a nonprofit if one is not available. I grew up in El Paso. It's the fourth largest city in the country. I continue to want to do good work, so we have to do it by necessity out of our office. We have 20 pro bono cases, and we've made the decision of representing individuals who help others. And so we've targeted those who could help build democratic institutions in Mexico. Social activists, human rights activists, and journalists. And we've made the hard decision. All the others we charge. And that funds this political work. And so we have seen that we're starting to have a dent in terms of doing this. But what we've done with this, based upon the work that the other community has done over the years in parroting that, is that we formed a group called Mexicanos en Exilio. And the board, to serve on the board, you have to be, there's two requirements: being chased by the Mexican government and seeking asylum. And that, of course, gives them some color of law, legal presence, which allows them to travel and to speak out. So we want to link up with organizations throughout the country and let them speak to the communities as to what's happening, because in order to change this quantitative, problem of high rates of denial, we want to inform people as to what's happening. And as Stalin said, one death is a tragedy, a million is a statistic. And so getting the word out that 40,000 people have been murdered means nothing. But when you hear these very articulate social activists, I think that deserve our help, changes the dynamics and I think the perception of our country. But just very briefly, the Central, especially the Central American and the Haitian experience, have been very, very important for us. And part of what I wanted to engender in this discussion was maybe recommendations, recalling what happened, and recommendations as to what we can do. And because from 80 to 92, I think it was the Salvadoran Civil War, there was a series of processes, legal processes, that the activist community, the Salvadoran community, and the immigrant rights community undertook to change this high denial rate in the 1980s. And that was pushing, class action lawsuits, which we haven't even begun to consider in the Mexican context. How can we frame that? It used to be the extended voluntary departure, which is now temporary protected status. Those were all political changes, but those were all political changes designed to deny asylum and give them another out, not to address it. Mm-hmm. We see that today with the Morton Memo. The Morton Memo is an executive branch policy written at the direction of Obama called, John Morton is the guy who heads up ICE, which basically says we can't deport everybody. And the problem is that and this is an nationwide problem that provides a solution to a problem they created. They've had too much success. They've arrested too many people coming out of the jails or being here with a lawful presence, but they've cut the budget and they don't have enough judges. We have in El Paso one judge, and he has 5,000 cases. To get the initial hearing, a master hearing before an immigration judge in El Paso is 2 years. That's when you file the I-589, and that's when you can get employment authorization. 150 days from the 2 years. And that's part of the politics of adjudication, is starving people, prolonged detention. And so there's a series of adjudicatory processes and bureaucratic processes that discourage Mexicans from applying. And so that's why we've been very visible with our case to say you can win. Of course, we've been winning them affirmatively with the asylum officers and now with the judges. And so there's a series of administrative tweaks that have been made. And the final tweak I'll mention, I think, which is geared towards dealing with the problem of the undocumented immigrant community, and to a large degree, I think, with the Mexican community, the onslaught of the Mexican community, because it is the largest group, is something that your professor addressed brilliantly in a law review article that I read dealing with the 10-year bar. And the president can do what he wants executively. With the signature, he changed the 10-year bar. 10-year bar is a process whereby individuals who've been living here unlawfully for more than a year, if they go back to Mexico to try to get their papers fixed, that triggers the 10-year bar, and you have to apply for a waiver and show extreme hardship to certain family members. That's very generally speaking. Now, they've allowed you, or they're going to allow, the rule is being developed, to allow people to get a stateside provisional waiver before you leave. That creates all kinds of other possible problems, but those are little tweaks that aren't enough, but I think those are responses politically to the community, but also, I think, to the situation. In Mexico, that's been a major problem to have the family, and they've cited that as a security issue of having family members in Juarez waiting for a year for their papers. And so there's a series of qualitative shifts. This is the lesson, I think, of the Central and the Haitian community, is that by continuing to push through either legislative or judicial processes, the sheer weight and number of those cases lead to qualitative changes. And I believe, beyond the election coming up, that what has been done collectively by the immigrant communities has led to those tweaks in the system at this point.
Thank you. And on that note, you've just laid out, I think, a lot of stuff for us to reflect on. Why don't we start with Sarah and kind of work our way back down here? Is that, to give us your thoughts on this.
Okay. I guess I'll speak into the microphone. Let me know if you can't hear. So this is really so perplexing. So I maybe just will give a little bit of background about what happened to the Salvadoran and Guatemalan community that Carlos was just referring to, because I think it's a really good example of exactly the problems when we talk about the percentage denials, unfair denials as reflected in the percentages of denial rates, but also about the very multi-pronged strategy that did change things. So back in the 1980s, there was a class action filed called American Baptist Churches versus Thornburg, and it was a class action of all the Salvadorans and Guatemalans in the United States who had come before that time, basically before 1990. And what the basis of the claim was that asylum claims from Salvadorans and Guatemalans were being denied at an unfairly disproportionate rate to the strength of their claims. Now, obviously, asylum is case by case, and you can't say that one individual from El Salvador should have won asylum because 5 others should have, it was similar to other people who were granted. And so what they did was they compared the litigation strategy, had named plaintiffs and unnamed plaintiffs, and the organization I worked for at that time in Seattle, we actually had both a named plaintiff and an unnamed plaintiff, 2 brothers from Guatemala who had fled. And the older brother was 18, and he had, I met with him in my very halting Spanish, which is very halting, tried to explain to them about, would you be willing to be a plaintiff? I don't think I even knew the word for that. And would you have your name used in this because it will help other people? And the older brother was really amazing, and he had been an activist in Guatemala, and his life really was at risk. So when he fled with his younger brother, and he immediately understood, and he said, even though this would put my life at greater risk, I'll do it because it would benefit so many other people. So he was incredibly brave to do that. And the amazing thing is that litigation, the class, was probably, 180,000 people, maybe more, Salvadoran and Guatemalans. And the theory then compared just at a very, gross level, what Carlos was saying, the grant rates for Salvadorans and Guatemalans at that time, which were like 3% or less, at a time that entire villages in Guatemala were disappearing due to the Army's scorch and burn tactics. Comparing those numbers to grant rates for Nicaraguans and Cuban asylum seekers, which were much higher than 50%, sometimes 80, 90%, because those claims were being brought as people fearing communists. And so, you'd think that we might have noticed the Cold War was over and these were, different dynamics at work. But this was exactly the point about asylum adjudications reflecting U.S. foreign policy concerns. And so during the course of that litigation, the government really had no defense to the discrepancy, other than the fact that asylum was just being used as an arm of U.S. foreign policy. So at the same time, claiming they were doing this on their own independently, they completely revised the asylum adjudication system, got it out from the local immigration offices, proposed regs to completely change it to make it a national asylum officer corps with human rights training and legal training and so on. And that was the study that I was involved in when I first came here, which was actually through the Harvard Immigration and Refugee Program, Debbie Anker and company. And so it was, we were trying to study the effectiveness of it. But through the course of the litigation, the government completely changed the asylum adjudication system and agreed in settlement negotiations to give every Salvadoran and Guatemalan who was still here, even people with final orders who'd been denied, a new asylum adjudication. And what they thought was, there just won't be that many people. Well, they were surprised. There were so many people that the new asylum system kind of was completely overloaded, sort of threatening to collapse under the weight of, 180,000 new applications or something. So ultimately that led to legislation that Congress passed, which would allow us another form of relief for Salvadorans and Guatemalans who had been here during this period of time, primarily if they could show good moral character and extreme hardship. And then due to advocacy, there was a presumption found that they would automatically be presumed to make that showing of extreme hardship if they were to be sent back. So kind of out of all these little threads, really, I guess what I'm trying to convey is the whole idea that it seems like you need almost everything working together. You need statistics, litigation. I don't think the rules would have changed for Salvadorans and Guatemalans had there not been litigation. backed up by these really strong statistics, yet at the same time it takes tremendous amount of advocacy, both with government officials, nonprofits, human rights organizations, kind of everybody coalescing at the same time, as well as organizations on the ground representing people. But to achieve, what really ended up being an amazing victory for Salvadorans and Guatemalans took, well over, maybe a couple of decades, really, and really requires all of us at whatever level that we're participating in to join the fight. So I'm not sure that answers anything, but anyway, lays it out a bit.
That's great.
I think it lays out quite a bit.
Okay. Okay.
All right. This is a little bit difficult because obviously we want to learn about the work you're doing and we want to add to it rather than have a debate as to who knows what, right? But I wanted to start by thanking Rachel for inviting us and for Northeastern in terms of organizing this event. I think this is a wonderful event, and this is something that we as a community in Boston really need more of. So we appreciate this happening at this place. A couple of things. First of all, I just sort of want to piggyback from what you're saying, which is all that work was an amazing. I mean, if you think back, it was the whole country. We learned from comparative law. We learned from other countries. We learned from Canada. We learned from Europe. We learned from the human rights struggle. There was a lot of issues that came together. There's a lot of struggles that came together that ended up with those incredible victories. And so, what could be added to it in a small way? Well, one of the things I would like to add is the fact that, in addition to the class action work, and I know you've mentioned this, a lot of us were involved in doing these individual cases. And I think you mentioned this, that in the 80s the judges wouldn't grant the cases. Well, in Boston, I believe in the 1980s, our friend Deborah Anker actually did a study, and in the Boston there was 9 cases granted by the judges. So we had the officers who were doing the adjudications who were in just regular immigration officers, and they were denying all these cases unless people came from communist countries, and they got the famous State Department opinion that said, oh yes, granting the case, they're real refugees. So other than that, they would never grant them. And then you went to the judges, and the immigration law, the refugee law had just been passed. It had just been enacted in 1980, and I think everybody sort of saw it, particularly the judges saw it as something like really weird or crazy or nothing to do with immigration or just sort of a farce. So the judges didn't take it serious at all. However, there was a lot of us who did these cases in the 80s because there was a lot of people coming in from Central America, from El Salvador and Guatemala, and also the other countries, but particularly Guatemala and El Salvador, that had incredible claims. These were people who were being targeted in ways that we now fully understand because after the war, a lot of this has been documented in a way that is not threatening to the powers that be because it's past history and it's human rights, etc. And now we understand that there was a lot of killings, there was a lot of targeting of people, there was a huge struggle. The people stood up and they got slaughtered for it, and they also got persecuted for it, and many of those people came here. So we did a lot of those cases, and in the beginning, you would do these cases and you'd always know you were going to lose. So what you did is you made sure you created a record that you could appeal, and we were doing like maybe 2 appeals a month to the board because everything was being denied. But slowly things started changing, in part because there were cases that were very strong and very easy for the judges to understand and the adjudicators to understand. Or in one case that I represented, a colleague of mine who actually works with me, he came from El Salvador, and the killing of he worked for a human rights organization, and the managers or the executive director had been killed just before he fled. Everybody had been threatened. It had been in the paper. It was something they just could not say did not happen. In fact, it was reported even by the State Department. So that case they just had to grant, but they wouldn't grant those cases. So anyway, we worked case by case, and slowly we were able to change the culture of the court. And then the asylum office comes in, and that really starts changing things because for once, people really started thinking through these cases, which is what we're all doing right now. In thinking through these cases, well-founded fear, past persecution, what's the nexus, what's the harm, what's the level of harm, is the government, state unwilling or unable to protect the person, is there countrywide persecution, are there bars? We were really having increasingly we started having adjudicators who were thinking this stuff through more clearly. And throughout the country, people were litigating these cases, going up to the board, going up to the federal courts, and over time, a lot of it has changed immensely. And so what I would say is I think your idea of picking some of the cases that you think can be used to put the issue on the table and then building on those cases is a great idea, and that's exactly what I think people have done around in so many places that have been successful. I would turn to the Haitian context and say when the coup took place, when Aristide was first deposed in 1990, I believe, right? 1991, actually. Yeah. There were, and a lot of people started fleeing Haiti, and the U.S. government tried to stop the people. There was all this litigation on these issues. But what really made a difference, I believe, is the fact that there were already a lot of Haitians in the United States who had some sort of status or had status, and they stood up for their people, their families, their colleagues, and they, in a sense, motivated the rest of us to stand up and to get involved in the fight. And I think that's a huge part of this struggle, which is what you're proposing, I think, is that people who are on the border, people who touch these issues, need to go out and talk to people and motivate people and make it a real political issue. And I think that was a very important piece. And in reality, in the beginning, when we did these Haitian cases, they weren't granting these cases. And particularly the asylum offices, over a period of time, ended up granting most of the cases that we ended up getting. We ended up getting a lot of people who came through, were able to come through, and the United States was forced to let into the United States to adjudicate their asylum claims. And most of those claims have actually been granted. Many of those people now have families who are on the ground here. Many of those people now have kids who are doctors, and in fact, there's a lot of people who are pharmacists, teachers. I mean, this is a community, right, that is very well established here in many ways. It's a middle-class community that's a really fighting community, has a lot of strength. So it comes from that experience. But the other thing I would like to add is that I think part of what we learned to do as we did that work is we learned to think through each of the individual cases. So, for example, as you deal with Mexican cases, the issue is right now you're dealing with human rights activists and political activists. And so one of the things that we've had to learn over time is how do you interpret, how do you understand, and how do you explain to the adjudicator what is a political opinion, right? What does it mean to do human rights activism? What does gender have to do with something? What does race have to do with something? I would imagine in northern Mexico, race is a big issue, right? And particularly in the United States is an issue. And so how do you put that on the table in a way that makes race the nexus in the claim, when race has always historically been one of the classical nexuses of any claim. But for some reason, the judges are afraid to even touch it at this point, and that's something that I find very interesting. So it's case by case. I think there's a strategy that's bottom up. You work each case, you figure out the issues, you figure out how to interpret it, you figure out how to document it. One thing that really struck me is that there's a number of cases that have been, I think, brought to the Inter-American Human Rights Court. I think there's at least 4 that even the State Department, I think, lists as actually putting on the table the harm and the reasons for the nexus and the lack of state protection, right? So I think that stuff, all that information, I think, is super crucial, and it's something to be built on and to be worked on. Additionally to that, we do a lot of Guatemalan cases at this point because there was a time when they were granting a lot of Guatemalan cases, and then because of the settlements that were put on the table, in a sense, there weren't that many Guatemalan cases on the table for us for a long time. And then after the raid started in the United States, we ended up realizing that one of the largest underground communities that had not been seeking asylum were the Guatemalan communities. And so now we've been working with them. And it's very clear to me that we need to figure out, but not only talk about conditions where the army attacks somebody in a civil conflict or a civil war conflict, but how do we deal with situations where the government attacks people when they're dealing with privatized struggles? What does it mean to struggle in a neoliberal economy? What form does that take? And I think this is what's happening around the drug issues, right? The government is taking the position that, no, we're just enforcing the law. These people are lawbreakers, and anybody who gets in between us and the lawbreakers, well, it's just collateral, and by the way, there's no nexus to it. When in fact, is very much part of what the struggles have become in neoliberal economies. And all of our economies are being neoliberalized, particularly in Mexico, right? And Calderon actually represents a lot of that neoliberalism, right? So that's where I think a sort of re-understanding of what all that means and changing the culture of the court and of the asylum office on these issues. So I don't know if that helps.
That helps me figure out.
Okay, so I prepared some remarks, and it's basically, to me, it's the politics of asylum and CPS for Haitian in the U.S. I'll try to be brief. John mentioned some things, and definitely he's right, but I think it's important to stress on the challenges. I think Haitians have probably faced the most discriminatory immigration policies in recent years. Since the 1970s, the U.S. government has been implementing a double standard policy for Haitian people seeking refuge here in the U.S. The government has used all types of excuses to deny Haitians their basic rights. 1970s, a few Haitians were tested for tuberculosis and right off the boat, and automatically the U.S. government stated that, well, they return all Haitians back to Haiti without informing them of their rights to due process, claiming that they bring tuberculosis to the U.S. In the 1980s, or specifically in 1980, Congress enacted a new refugee law that, for the first time, unequivocally guaranteed asylum to any migrant from any country arriving in the U.S. and able to demonstrate a personal, well-founded fear of persecution on account of rape, religion, national membership in a particular social group or political opinion. Of course, this law did not apply to Haitians. Despite gross human rights violations with intense atrocities in the years during the Duvalier regime, we're talking about, of course, Papa Dog and Baby Dog. We're talking about the CNG, which is the National Council of Government, and you had tons of people being killed all the time, thousands, and of course the Avril administration in the 1980s, the INS and State Department continued to regard Haitians exclusively as economic migrants rather than as individuals threatened with persecution. Yes, indeed, the law did not apply to the Haitian folks. George H.W. Bush ordered the Coast Guard to return all the boat people to Haiti, regardless of their status. Of course, critics argue that this new policy violated the Geneva Convention on Refugees and its protocol, which the United States had signed. We won't go into the Geneva Convention, but Bill Clinton, of course, was elected in he was the president. He became the president in 1993, and this is right after the coup d'etat with Aristide in 1991, where a lot of people got killed, murdered, and he continued Bush's policy, returning folks to get killed in Haiti. He argued that prohibiting the immigration of Haitian refugees would prevent many Haitians from drowning in an attempted ocean crossing. Okay, this is the same president who admitted back in 2009 that U.S. did more harm than good to the country in terms of destroying its economics or economy. Today, this is the man who, in my opinion, is the governor of Haiti, because he's the special envoy, UN envoy to Haiti. Now, Haitians continue to be expelled from the U.S. waters and sent back to poverty. We say poverty, there are some poverties, there is poverty in Haiti, but a lot of political dangers, political repression. So in 2003, again, Attorney General John Ashcroft announced that Haitians who make it to the American soil and apply for asylum will be detained on grounds of national security until their asylum cases are settled. Now, of course, the U.S. is obligated by law to afford any refugee seeking a safe haven the right to due process, which, you know, us Haitian folks, we didn't get, we still don't get. Instead of, they send the Haitians back home, and we do say, instead of sending the Haitians back home, the Haitians should be able to state why they're living in fear and have the right to political asylum. Now, of course, while all the Cubans are informed of their rights, even through interpreters, on the U.S. coast boats, but as for Haitians, never got the same treatment. They are, us Haitian folks, it's been a long battle. We have made some gains over the years with a lot of organizing, but the conditions still continue to be tough. Very few Haitians were granted asylum in the 2000, 2001, 2003. You hear cases where you could have 400 cases, and out of 400, you might get 11. When you hear the intense or the changes over time, it's because of the intense mobilizing, organizing work with, I give credit to primarily a lot of grassroots folks, and in Miami, in Boston, New York, but specifically Miami with groups like, well, I won't name them, there are quite a few, but Haitian folks, Haitian leaders who have taken the lead, but you have a lot of legal service providers too, who truly believe in human rights, and you have groups like ACLU, Catholic Charities, just to name a few. Now, in regards to TPS, temporary protected status, Haitians and other advocates definitely have fought vigorously since, I would say, 2006. We have had a lot of natural disasters, and you remember 2004, 2008, we had 3 hurricanes that hit Haiti with thousands of people dying, over 300,000 homeless. And guess what? We met all of the conditions for temporary protected status, but did we get it? No, we did not. So it wasn't until the January 12th earthquake that things changed. Now, we did get, Haitians were finally granted TPS after the January 12, 2010 earthquake. The Obama administration gave temporary protected status to unauthorized Haitian immigrants living in the United States. But soon after that, and we were all very happy, we thanked them, we invited politicians to our meeting, et cetera, et cetera. But soon afterwards, we had to reorganize to advocate for not only extension, but redesignation. I'll explain. While many of the countries who have gotten granted TPS protected temporary status in the past would get a period of 2 to 3 months, sometimes more, to really do the paperwork, etc., or to have a cut-off time that makes sense. With Haitian folks, it was the same day of the earthquake. It's not 2, 3, 4, 5, 6 months after the earthquake. It was the same day of the earthquake. So again, we got to mobilize. We mobilized, and we did get some results. We received not only the extension, the redesignation. So not only folks who were living here were able to get some relief, but also some folks who were airlifted after the earthquake for medical services, and some other folks. But what we want to say here, TPS is good, and we thank the Obama administration. But TPS is not asylum. Of course, the folks who have received TPS will not, we hope, be deported, never deported to, be deported to Haiti, but this doesn't guarantee a permanent residence as well. So the challenge continues. The challenge in terms of ensuring that there's extension, you have to renew it right now, and I'm sure there's a few, I think folks from, a couple of folks from Central America have to renew it soon. So it's a lot of work. It's a lot of work with the attorneys, with the community advocates, and we feel as if we made some gains, and we say thank you, but the fight continues. It continues for a lot of different ethnic groups. But one thing I'd like to add, or close with, it has been proven over and over again that the U.S. continuously discriminates against Haitians. But we say, we as human rights advocates, We demand that the U.S. government stops the double standard against Haitians and approve family reunification parole, just like they do for the Cubans. And they've been renewing. This is a situation where, let's say, I am a U.S. citizen or I am a permanent resident. I have the possibility to send for my husband, my wife, my children in Haiti. Instead of having those folks after the earthquake stay in Haiti, you know, there's years of backlog. Instead of staying for 15, 20, 5, 10 years, why not let them come? Because I filled out all the paperwork. You know it's going to happen. It's a matter of time. You do it for other places. The Cubans get it all the time. So we say it's the only right thing to do to help Haitian folks in Haiti, to help Haiti, especially after the January 12th earthquake. So we are on a mission to see if the U.S. would approve this family reunification parole for Haitians, and it's simply a signature from the president. And more importantly, I think we need to go beyond the Haitian cases. We need comprehensive immigration policy. Thank you.
Thank you all. I have some questions for you, but first I just want to open it up to respond to each other in any way that you'd like.
Well, you know, if I may, one of the common denominators of the three presentations is that there are clearly political considerations by the U.S. government in each case. The government is, if anything, creative and resourceful. In each case, there's a different reason. For the Haitians, it was the health grounds of inadmissibility and economic refugees. You're economic refugees, you're not political refugees. Same thing with the Central Americans. You're fleeing generalized violence, and you're economic refugees. In the Mexican case right now, the main reason is that you're fleeing criminal violence. And so the task is to connect the corruption and the violence. It's one and the same. The Chapo Guzman controls the military is part of Chapo Guzman. We have all kinds of evidence. And remember, an asylum claim is just a reasonable, do you believe it? Is it a reasonable belief that you're going to be persecuted by one or the other? And I think one of the other distinctions, or maybe I would like to hear your comments on what role did the argument of the unwilling or unable to protect standard play in that? Because that's kind of one of the big things we're using in our next set of cases, because right now they're political activists with political opinion, but the next set is people who are being persecuted and extorted by the criminal cartels who are acting with absolute impunity. And so at that point, the government is unable and unwilling to protect them. And it's really, I think that's one of the areas of research that we're looking for is extortion. In Mexico and Juarez, we don't have carjackings. We have housejackings. They are charging people to live in their homes or we'll burn them down, house to house. They have the military going house to house, taking food off people's plate. That's one issue because that's the state. But in terms of extortions on a massive level of businesses who are complaining and filing human rights complaints but nothing's being done. And that area of extortion I think is ripe for litigation in a new way, and we're trying to look in those two areas in the Mexican context: extortion and unable or unwilling to protect.
Yeah, and that's a tough one. Yeah, because as I'm sure you've learned through your exposure to Asylum, the Asylum law draws this clear distinction between people fleeing for economic reasons or people fleeing on account of one of the 5 reasons recognized in the Act that Carlene was mentioning about political opinion, social group, race, nationality, and so on. But what's interesting, just the coincidence of this is a very old case that I think is a Ninth Circuit case that's still good law that arose in Haiti during the time of the Duvaliers and the power of the Tonton at that time, that the court called the government a kleptocracy. And so people who refused to basically to pay the bribes to do what they were being extorted to do, that was characterized successfully as political opinion. So that, again, goes back 20, I think it's from the 1980s. And then there have been some cases in between that do recognize that economic motivation could be part of it for guerrilla organizations or any groups extorting, provided that a central reason as well, even if there's dual motivation, a central reason is one of the protected grounds. I'm sure you know that better than anyone. There's only one other thing I wanted to mention that Carlene was mentioning, just to make sure people realize this, because when I learned it, I was shocked. She was talking about Haitians being interdicted on the high seas, and the U.S. In the 1980s sent Coast Guard cutters out to stop boatloads of refugees fleeing. And on the cutters, they conducted interviews to see if people really had a basis of an asylum claim. And all during the Duvalier regime, I think throughout the 80s, I think they let in like 10 people when there were massive human rights violations going on. And so then what happened after the coup, when Aristide was overthrown, is that so many people fled that on the Coast Guard cutters, they sent down asylum officers to help do screenings. They couldn't, there were so many people on those boats, they couldn't remember. They couldn't figure out which ones they had screened in and which ones they had screened out. It was just, there were just too many people. So they opened, if you may remember, Guantanamo Bay to do screening for credible fear interviews. So this was, and there was litigation over that. So this was earlier, way earlier Guantanamo Bay litigation that again was brought by the Yale Law School Clinic. Harold Koh is now an advisor to the top legal advisor in the State Department to the president, as well as the ACLU and pro bono council organizations representing Haitians. And they had, the case went to the Supreme Court. They had some victories, but it was, and some failures, but there was a question of the reach of the protections that the U.S. has guaranteed to people, whether they extended beyond the territorial boundaries of the U.S. But it's chilling that, with our Statue of Liberty type country, that the U.S. sends Coast Guard cutters out to stop refugees from getting here.
I think those are important points. I mean, I think at the beginning they actually just sent the Coast Guard cutters out and stopped them. And then actually as people started litigating the case and started organizing, then they started sending the asylum officers.
Put them somewhere, yeah.
So they were forced to do that as well. And I think they still do this when there are issues. They're always concerned there's going to be movements of people, and they send people out. They send cutters out all the time, I believe. A number of these stories are such, I believe, when they couldn't figure out who was who, part of it had to do with the fact that the boats were really in bad shape by the time they picked people up. And as they would pick people up, the boats would sink, so they had no choice but to carry them with them as well. So these stories are amazing. And I think one thing that always drives it for me when I talk to a client and I'm trying to determine whether there is a case is, why did you leave? And why did you take such a risk on your life if you left? I mean, that to me helps inform what the underlying reasons are. Is there a case there? And in the Haitian cases, you're exactly right. People were traveling by night. They were making these arrangements to get on these boats, if I'm right, to come off. There was a couple of islands that they were on because they were really, really in fear of their life. And they took incredible risks because they knew a lot of people were dying. It's been a historical thing that people who fled, who've traveled those waters in these small boats have died. So people took these incredible risks. Anyway, the other thing that strikes me is that, once again, the U.S. government is involved with all these governments, right? They're funding these wars. And so I think there is a way in which, you're right. I mean, it is a question of political policy as to what they're going to do with the government that they're actually supporting. In the Guatemalan situation, as is becoming increasingly clear, over the years, I mean, there's been a very, very important set of Truth Commission reports, or a Truth Commission report that came out of Guatemala, and another one that came out of the Catholic Church that actually was very clear about documenting what the government was involved with and how systemically it was involved in persecuting and persecuting the war of genocide. So this stuff is coming out now But at the time, the U.S. government was very much involved and was taking a position against these people. So I would imagine that in Mexico, this is the same issue, and this is what's on the table, and what are they going to open the doors for? But once again, it's their client states in many ways, right? And so this is a big issue. Now, for me, there's two parts: is unable or unwilling to protect people. So, okay, the unwillingness stuff sometimes gets a little bit, it's harder to deal with in these particular cases. But I'm sorry, the unwilling is where I think these issues come up. Because, in fact, the government is very much involved. There's a lot of studies being done that it is very systemic, it's top-down, it's a culture that's being created within the armed forces, etc. Right? So that is something, I think, to think through. And a lot of work is being done in Central America on these issues. The coming together of the gangs, the coming together of the criminal cartels and the government, and in fact they're becoming part of this sort of shadow state that's been in place for many, many years, and that's how these cases are being argued, and I think that might be helpful as well. I'm not sure.
I'm going to throw out a question to you here. Does any of this, thinking through these examples and sort of the deja vu quality to some extent of the Mexican cases now, does any of this make us, should any of it make us question our default response, which is generally a country-specific response? That is, through litigation or legislation or whatever we've done, I mean, there have been responses that have focused on the Guatemalan and Salvadoran cases or the Haitian cases. Or is that, and now, you know, some of that led to system-wide changes in the asylum office in all kinds of ways that then sort of, you know, presumably benefit everyone, or changes in the legal frameworks that sort of, you know, pushing these new theories of particular social group, but we tend to, whether it's TPS or, you know, in other ways, and I think there might be reasons for that, right? From an organizing perspective, there might be reasons. I mean, there may be some good reasons for that, but does any of this make us think about that differently? Does anyone have any thoughts on that, given what we're dealing with now, or is that the way this should happen?
Well, you know, I think in my opinion, the only one who's thinking that way is the government, in terms of identifying specific problems that exist that are similar but different in immigrant communities throughout the country, and resolving it through executive fiat, which is like the Morton Memo. That's for everybody. This thing about going abroad on this 3 and 10-year bar, that's for everybody. It's not what everybody wants in terms of comprehensive immigration reform, but I can tell you my clients are happier than hell, and we've stopped a lot of deportations with the Morton Memo. And I'm sure that's happening throughout the country and in different communities. And so at least we have something. Is it a political ploy for Obama to give something to the immigrant community, especially the growing Hispanic community? Or is it really an effort to address the concerns of all of them? But I mean, but I think you're right. There is a piecemeal thing, because the issue with the Central Americans is ultimately they didn't get asylum. They were successful in denying asylum with all the other measures. Now, the other thing that was happening that I think was part and parcel of that was amnesty. Amnesty was passed in November 6th of '86, and it was for people that were working here for 90 days in the agricultural fields, 84, 85, 86. This is at the height of the Civil War. So that probably incorporated a lot, but clearly not sufficient. And people that were here before January 1st of '82, which would catch the first wave. So that may have been part of, you know, the collective pressure the Central American community is give them now something that addresses concerns, but for some reason they do. You know, they do want to address the issue of political asylum as a matter of law or legislation, and that's really what you're addressing: is should we readapt or push for broader definitions legislatively, you know, in light of new realities?
Well, you know, I can just say what I see happening with the 1996 immigration law, with so many different complications and problems, and you have one section. I think sometimes well, I'm not going to criticize who wrote the law, but you wonder whether folks were really thinking straight. And since I think a year or two after the 1996 immigration law, it was clear that we got to fix it. Then we have dismobilization, in terms of fixing 96. Going, and you had folks from all over the country meeting to see how we can change. It's still not fixed, by the way. We're still working on it. So hence the need for individual ethnic communities to lobby their politicians to see if they could bring about some change for specific challenges in different communities or in different countries. So that's what you see happening. You have connections, whether at the city, state, especially at the federal level, and you connect with XYZ senator or congressperson, people, and then maybe, depending how well you express yourself, and it takes years sometime to even get to that level, and maybe they might want to sponsor something for you. So that's how it's been done over the years. I don't know whether folks agree. Is it the right thing to, maybe I don't see it that way, but if that's the system we have in place, that's how you get things done. You have no choice but to follow the same path. So in 1995, we did end up getting the Haitian Refugee Immigration Fairness Act, and Nahawa, was it the one that passed? So we were so upset. We were very happy for the Latino folks, but I said, how about us? You've been neglecting us. You've been discriminating against us. So we had tons of folks mobilizing all over to see if a couple of different Congress folks would help with this act, and finally it happened. So you have that going on, and today I think we want to change it. But I think there's going to be always country-specific needs that we need to address.
Yeah. I guess just to add to that, the odd thing about NACARA we were saying, which helped give legal status to Salvadorans and Guatemalans, if you take a look at it, you're going to find all these Eastern European countries listed in there too.
Yes.
And that was political necessity in order to get enough votes. So, yeah, I guess I would just agree. It's not the way things should be happening, but it seems to be the way things do happen. I don't know. Can you want to pair up Iraqis and Mexicans?
Mexican Fairness Act.
Well, can I just say something? Let's be clear about it. This country is really divided on these issues, and a lot of it has to do with race. And so, as far as I'm concerned, one part of the country not only does not want to pass any new laws, but they want to make 1990s ERIRA, which was passed in 1996, even worse. And so there's that. And then there's another group of us who are there's a spectrum of people who say, well, we should do something, to a lot of people who say we don't even believe in the borders because it doesn't make any sense anymore. So this country is really split, and that's one of the reasons why I think the communities that are organizing on these issues, and there's a very strong and broad pro-immigrant rights struggle going on in this country, not only by human rights people, but by the individual communities, by people who are working on a lot of other issues like labor issues, et cetera, who understand that this is such an important issue in this country right now, and we need to fight it. And so I'm just saying what is on the table is the fact that we're very divided, and a lot of people just don't want illegals in this country unless they're working for them or in chain gangs. And that's what the issue is, okay? The Obama people, I think, are trying to make changes for whatever reason, but the truth is they're trying to make changes. But even internally, we see it that the people on the ground, the trial attorneys, the officers, deportation removal, they're very much against what the Obama people are doing. They're accusing them. Their unions are going to Congress and are attacking the administration for making even an attempt to make these changes. So this is a huge political battle that it has to do with a lot of stuff, including race,
And more folks have been deported back home under the Obama administration. We all agree to that. Yeah.
But I think to be fair about that, it's a train that took off basically
before, yeah.
And after 2001, and that train has so much money. They put so much money into that law enforcement, and so many people are committed to these issues that it keeps on going down the track whether the Obama people try to change it or not. So as much as I'm not a Democrat, I'll be honest with you, I think we have to know who is really calling the shots on this stuff. And it isn't like this is their policy, because I don't think in the end this is really where they think it's going. When the raids took place in 2007, we ended up representing a number of people who picked up in New Bedford, and at that point it became very clear that under the Bush administration there was a policy in place of removing 10 million people in 10 years, and that's the policy that keeps on going. And the Obama people made their deals, but that's not their policy. They just can't really stop it, and they haven't been able to change it. You know, that's my line, but I'm just saying.
Yeah. Well, let's open it up, I think, to all of you and get some questions from. Yes, Fatima.
Colleen, I really appreciate your very honest portrayal of the experiences, and you mentioned national security as taking the 10th anniversary of Guantanamo since 9/11. I'm really curious about the after the creation of the DHS, the post 9/11 national security mindset on all these issues. It's very clear that even amongst the asylum seekers, there's a higher. Has that changed with this stuff? And I'm thinking about like last year, you had unprecedented revolutions in the Middle East, and some of them are from governments that the U.S. clearly supports. I'm wondering, if they come here seeking asylum in this post 9/11 framework, what's happened and because I think that the DHS and the creation of immigrants as a national security threat is really the big issue.
I'm being asked to just repeat the questions since the questions aren't being recorded. So the question is just what's the post 9/11 kind of take on this issue? Has that framework altered the way these issues are playing out?
Well, I think definitely it's more difficult. There are a lot of changes in a lot of the asylum cases, and we in the Haitian community there's a lot of fear. Even when they pass out temporary protected status, we know that the government is looking, right? And NSA, right? Records everything, right? And we know with the Secuse community how there's a lot of communication, taking place with the federal government, the state, the city. So there's this fear, that two things are happening in terms of for the folks who may not have status or may have status, that could change overnight, even if you're not. Even if you're a citizen, they can take away that citizenship from you. And I do believe that past 9/11, things have changed over the years. Now, in regards to what's happening in the Middle East, of course, we hear stories. We don't know exactly what to make of the stories, but we suspect certain things do happen. And we see a lot of folks getting here from the Middle East, especially people who have worked with the government, and even those, there are a few, we hear it on NPR all the time, who have really made a lot of sacrifice just to work with the military, and still, they're not getting the visa, they're not getting what they need to get into the United States. So I guess I can't really fully answer the questions because I don't have the facts, but I do believe it has changed a lot of things in regards to immigration, not only in the Middle East, but also all over the world, including the Caribbean and Central America as well.
One of the, I think, maybe intended consequences of that new enforcement policy vis-a-vis the terrorist provisions and increased security is experienced on a daily basis at the border. I can fly quicker to Houston than cross the border from El Juarez to El Paso. It takes over 2 hours, and that's because they're checking everyone individually, fingerprints, cards, and that's putting a lot of people into the system. Someone who had a conviction 50 years ago is an arriving alien. Someone who had a drug charge that happened, that was acquitted or dismissed, shows up. Your reasonable belief that they're a drug trafficker, even if it wasn't at the bridge. And so there's a lot of people who are thrown into the system, and that's part of the delay at the bridge, but that's also led to a lot of arrests and removals as they take the opportunity to tighten the noose with every new provision that they get, it seems.
Can I ask you a question? I understand they built new detention camps on the border in Texas, and some of them are like on these huge concrete slabs. Is that true? Or can you explain this?
What do you mean by concrete slab?
Well, what I was told is they have these huge concrete slabs that they're putting like tents on now, so they can hold people.
There's some in South Texas that I haven't visited or been aware of. You may be referring to Arizona, no?
No, it's Texas. It's Texas. Arizona.
The tent, yeah. The tent.
But no, I mean, we've got 2 immigration camps that hold over 1,000 each, and then in Sierra Blanca, another detention center, and the county jail. But 70% of the U.S. Attorney's docket are immigration crimes.
Yeah.
So first, I just wanted to thank you all so much. It's so valuable, everything that I've been I'm sure it was even I wanted to know, based on this policy that you were, John, that you have mentioned, of the, what is it, 10 million? How, I mean, that just sounds totally, how do you attack that? How would you, in the past, if there's been policies that are outrageous, and there's lots of them, throughout history, policy, how do you put things in place to impede
That's a very good question, and it's something that I think people in this country, all of us, have been working on for a while now. In one particular case, what happened is that because of that policy, the government had instituted this policy of doing these factory raids. So there were a number of factory raids that were taking place in different parts of this country, including Pennsylvania, that weren't really fought out because people didn't have a lot of chance. There wasn't a support. The factory raid took place here in New Bedford. We as a community, all of us, all of us got together and we fought this issue out. We still have cases on from 5 years ago. So what we ended up doing was fighting for the rights, the due process rights. We also went to federal court on these issues, as well as the individual rights, because the federal court basically ended up ruling that because of these jurisdiction stripping provisions that have been put in the law in 1996, which is one of the reasons that these class actions are not being done as often as we used to do in the past, because we were much more successful. The government actually learned, and they changed the law in 1996 under Alira, so that it was much harder to do this. But we also went to court on those issues, and through that process, the judges ended up saying to us, you can only raise these due process issues through each individual case. And when each individual case comes up to us in the Second Circuit, or to the First Circuit on a petition for review, we will then decide these issues, which was total, I'll be honest with you, it's not true at all, because it's very hard to raise these issues in immigration proceedings. So this story isn't over yet, but that's how we ended up doing, is organizing as a group to stop these raids, and then organizing individuals and getting involved politically to try to change the law. And that's one of the reasons why a lot of people mobilized around Obama, because we were hoping that was going to happen, and it hasn't. So these are the issues.
And just to mention also, this sort of shift that we're hearing about with this more memo, prosecutorial discretion, the idea of closing cases of people who are in the system. It isn't happening. The memo went out. That's what's happening. It's not being realized yet, but it took a lot of advocacy even just to get that memo. It didn't take a tremendous amount more advocacy to make sure that cases actually are closed. But what we see is Obama shifting to say, we're just going after the criminals, we're just going after the absconders. Well, okay, we have 2 programs, an asylum program and a detention program. The detention program has all these so-called criminals and absconders. People who are refugees. We're currently representing a young man from Sudan. So his father was murdered. He grew up in a refugee camp. He, of course, to deal with what he experienced as a young boy, has issues, with substance abuse. But there is a refugee waiver for that. So we're representing him. But he's one of these so-called criminals who is now a high priority in the Obama administration. Similarly, absconders, that brings to mind something scary and terrible. There are people who miss their court hearing. And so we recently represented a woman she was Guatemala, as John was saying, just a lot of new Guatemalan cases. Now, she never knew that she had a case. She grew up in a killing field in her town. Her church was used sort of as central operations for the military, and she walked past mass graves as she would just walk in her village. She didn't know that was an asylum case because that's how she grew up. So she didn't go to her hearing. She never applied for asylum. So she was a quote absconder. We were able to get her case reopened, and she was granted. But this is the problem, with even when you have a president who's trying to undo this a bit and not deport, everyone. First, you have to get it implemented, which it isn't without all this advocacy. But then even the categories that they divide up don't make sense.
Well, could I just add one thing? I think one of the reasons that the woman didn't know she had a claim is because she's indigenous, right?
That's good.
And as far as she was concerned, the non-indigenous world never cared about them. They have no value in that world. So she thought nobody would ever listen to her or care. And of course she didn't go asylum law or human rights law, but still, she never thought anybody would listen to her.
I think sort of a hidden elephant in the room is not only the question of La Merida and those political considerations that people have in considering Mexican asylum cases, but also the fact that the U.S. shares a land border with Mexico, and this floodgates fear. And so, and given the millions of Mexicans who were in the United States prior to 2006, prior to President coming into office, TPS is not going to be an option for the Mexican population in the United States. And so I'm really curious, especially as we're trying to bring these asylum cases, what other administrative tweaks or other tools do we have at our disposal that can be used to help people feel safe and secure in the coming years? Just because right now there's tens of thousands of people people that are here. Yeah, tens of thousands of people who are just living in the shadows, have no protection, not bringing asylum claims because they fear detention or deportation.
Well, the floodgate argument has been used with every community, but you're right, it's especially poignant along the border and easier to sell. It's with the Haitians, the Central Americans, and we're just going to open up the floodgates. When you're talking about Mexicans, it's a little late to be talking about that. Half of them stayed after 1848. So, but I think it's all about what she has said and what she has said and what he has said about its advocacy, its continuous advocacy, and there's different levels of enforcement throughout the country to include officers and TAs and judges opposing this Morton memo. We've had some success with it, and because there's a coalition in El Paso with the church and everybody else who's starting to put pressure, and AILA's is monitoring it as well, and we're making noise, and we've gotten certain people real clean cases closed. But I think the Morton memo has empowered me in terms of certain political asylum cases of going forward, because I've got a couple of cases where it could go either way. But of course, asylum gets you residency, and the Morton memo doesn't. So it's good to have a plan B, but that may go out if Obama's thrown out. So that's with the swipe of a pen. But I think there's traditionally you have deferred enforcement, deferred action. They can do whatever they want, but that would not be maybe a policy, but by case basis. But in the Mexican activist community, in the Latino community, the Mexican, there's been, Ruben and the Annunciation House has been throwing out the idea of TPS, if nothing else, as a political call, clarion call for justice, and basically using it that if you don't give asylum, then we want TPS, based upon the Central American experience. To what degree? That's way out there, but there would be too many to give to. But I really think that this Morton memo, it's a big concern of the Southwest. It's the largest immigrant group in the country. That a lot of it was probably you have these guys sitting around saying, what can we come up with to shut them up and simultaneously create an escape valve? And I think this is brilliant. Now, the enforcement is the other aspect of it, that as soon as a Morton memo passed, we had raids where they were taking them directly to the border. I mean, that's their way of dealing with it.
So I think we have time for one more quick question and quick answer.
Just wanted to say that the wars in Central America are still not over. More people are being killed now than in the Guatemalan Civil War. And being a child born during the worst years of the Civil War and being very close to the women organizations now, I feel that there is a lot of fear for the human rights defenders. Now there's a lot of state crime, and those human rights reports haven't been developed without deaths. One of those cases is the Daynard case, which I'm sure you're familiar with. And so my question is, what is your take on the femicide cases? I know that there have been a couple of successful asylum cases. And what is your experience with femicide?
Thing is, okay, so we're representing a lot of people from Central America. A lot of them are kids, and a lot of the kids are young women, and also older women, because they're coming here and they're the factory workers. They were the people who were the kids who grew up during the political violence, as they call it. It's still political violence, but the old period. And these are the people who, in many ways, kept things together, helped their families survive, and then they get targeted because they were the people who were the glue of the community or were connected to people that were being targeted by other people. So we have a lot of cases where women are now coming forward. And of these cases, the gender issue is a very important part of it. Not only in terms of why they left, because a lot of women were targeted because of that, on that basis, and also because of domestic violence, because the violence of the war, I think, really engenders a machismo amongst men who are fighting these wars, and before you know it, they think they own every woman in town. So there's all these issues. So the past persecution part of it definitely involves the gender issue. The well-founded fear future part of these cases involves sort of an independent woman's claim. A lot of women are saying, I have learned my rights here. It's not like this is a perfect place, but the thing is, I have been touched by what's going on, and I know I have rights, and if I go back as a single mother, because a lot of women are not living with men or are not going to go back with their partners because the partners can't go back, I will be targeted because of what is being called femicide. So this is a very important part of it. I do know that there are judges here who there was one judge who just went to Chicago who was very concerned about the statistics coming out of this type of attack on women, and we have been winning these cases. But again, that's not the only basis for this case. There's a Ninth Circuit case that is dealing specifically with that issue. There's no past persecution. It's more of a well-founded fear future case. And I think that's sort of like not a great case to take this on, but those cases are very much on the table, and these are the cases that women are presenting, and a lot of them are winning.
Thank you all for coming. This was really wonderful. I wish we could keep going for another hour, but we're at the end, and so thank you.